Alrighty, so Chapter 9 deals with contract law. And this is another big section of the test, and I will also be real honest with you and tell you it's one of those things that people really, really struggle with. If you think people struggle with agency, contract law is probably the biggest challenge. And that's largely because society has lied to you your whole life about what a contract is and what it's for. Most of you have been conditioned to think that you cannot exist on this planet without having a contract for everything. The purpose of a contract, folks, is not to make a transaction happen. And that's going to be the biggest disconnect in your brain that will keep you from getting the questions right on the test, is you will start to think of the contract as the thing that makes a transaction happen. That's not what it is. A contract is the thing that makes sure everybody else knows what these two people have promised to each other. See, that's not important if those two people do what they promised they would do. When does it become important that we have a document that shows the world what they promised to do? When they what? When they don't do what they promised to do. When they stop doing what they promised to do. When one or the other of them says, this is not right. This is not what you said you were going to do. And that's when a contract becomes important. Here's the truth. We spend all this time talking about them. We spend all this time working on them. 99% of the time in your real estate career, the contract and the transaction is not going to matter. As a matter of fact, you may go through your whole real estate career without the contract mattering. I hope you do. Because if you go through a transaction without the contract mattering, what does that mean happened during the course of the transactions? Nothing went bad. Nothing went bad. I have never seen at a closing, like for example, I have a closing on Wednesday morning, and I'm on the listing side. Do you think I'm going to walk in that closing on Wednesday morning with a copy of the contract and go, wait a minute, hold on. Let's look through these 11 pages and make sure everybody has done what they promised they do before we let you buy this house? Are we going to have that discussion? If somebody does that, you hit them hard. Because if the buyer's there and they got money and the seller's there with a deed, guess what you better be doing? You better be closing. Does that make sense for everybody? At that point, it doesn't matter what they promised to do. What matters is they've shown up and they're ready to move forward. And that's going to be the case the vast majority of the time in real estate transactions. I'm not saying that to minimize the importance of contracts. I'm saying that to get you in the right frame of mind for what a contract really is. So since contracts only really matter when you go or when you have a disagreement, where is that disagreement going to be settled? In court. That's where they matter. That's where this phrase, legally enforceable, comes into play. Legally enforceable doesn't mean that the two parties promised to do something. We understand that. That's the whole reason they're having a dispute right now, is because somebody promised to do something and the other party feels they haven't done it. Does that make sense for everybody? That's not a contract. Contract is not the promise. The contract is whether or not a court will enforce the promise. Would a court of law look at that document and go, yes, this is a real promise, and both of these parties have to do what they promised to do? That's what the word enforceable means. It doesn't mean can they do it. Can people do pretty much whatever they want to do? Absolutely. So even if we don't have a valid contract, can two parties close a real estate transaction? Sure they can. If the buyer shows up with money, guess what we're going to do? Close. Nobody's going to ask for a copy of the contract at that point in time. Because at that point in time, the contract doesn't matter. Clearly, the two parties must be satisfied with what's going on, because the buyer showed up with what? And the seller showed up with what? A deed. If they're satisfied, who are we to tell them to stop? Are y'all with me on that? The contract only matters if those two parties get in a disagreement with each other, and they do that in a court of law. That's why we talk about it's a legally enforceable promise. And here's why this whole chapter is so important. Not every promise is legally enforceable. There are certain promises that really are just between the two parties who made the promise, that they cannot enforce that promise on you legally. So I want to give you an example, because I think it's sometimes nice to take it out of a real estate context, give it to you in a different example so you can understand what I'm getting at. Can two people who are in a relationship with one another have a promise to be faithful to each other? Can that promise be legally enforceable? Sure it can. What do we call that when we make that promise legally enforceable? Marriage. Marriage makes that promise legally enforceable. If you don't believe it, go look at what divorce lawsuits are filed for. What is the cause for divorce? Infidelity, right? You're suing somebody because they broke a what? A promise, a contract, a legally enforceable contract. Now, can two people who are just dating have the exact same promise with each other? Sure they can. They can have the exact same promise. You see how much you struggle with it now? Wait till we put it with real estate. See, you don't even understand it with dating. Can they make a promise to one another? Yes. Is there a huge gaping difference between those two parties making a promise to each other and those two parties making the same promise to each other in a way that a court of law would get involved and force them to do what they promised to do, or hold them responsible if they didn't do what they promised? Do you see what I'm saying with the difference? If you're just dating somebody and they cheat on you, you're going to go to court and sue them. You might try. What's the judge going to say? Get out of my face. Stop wasting my time. The exact same promise made between two people who have gotten what? Married. Is the judge going to entertain that argument? Not only are they going to entertain it, are they going to enforce it? And if you don't believe it's enforceable, ask this gentleman in Marsville now who has to pay somebody $8 million for alienation of affection because he slept with somebody's wife. It wasn't even him that was cheating. And you know why he can be held responsible for that? And it has nothing to do with love and matrimony. It has everything to do with he violated the contract, the legal contract between those two parties. The home wrecker. Yeah, $8 million.
So isn't it a contract that he would have to, or somebody would have to pay the
When did the home wrecker sign the contract?
He didn't.
The home wrecker didn't. But
He didn't. He's interfering with a contract that he knew existed.
He didn't now, so they proved that he...
They proved he was very much aware. And I'm not defending the alienation of affection laws, but I'm trying to demonstrate to you the difference between a promise and a legally enforceable one. Does that make sense for everybody? So here's going to be the reality. Real estate works the same way because it's all contract law. Marriage law really is just contract law, by the way. It's all contract law. Can a buyer and a seller make a promise to each other? Can a landlord and a tenant make a promise to each other? Can we go one step further and make those promises legally enforceable? Yes. Our goal as real estate brokers is to understand the difference. Our goal is to understand when we have made those promises legally enforceable, because we have not done our job. Would you think that a real estate broker who allows their seller to go into a deal with an unenforceable contract could be held responsible for that? Absolutely. Have you not misrepresented your seller? Haven't you done a terrible job? Because if at the end of the day your seller has pulled their house off the market expecting this buyer to buy it, and the buyer just goes, I was kidding, and they walk away, have you done a disservice to your seller? Because you didn't understand the difference between a promise and a legally enforceable promise, because they are two different things. Is everybody with me on that? So this chapter is all about what it takes to make that promise a legally enforceable one. To go from just a promise, which can be broken, to one that has very real penalties to being broken. Are you with me? That's the difference. That's what contract law is all about. And I have to get you in that mindset so that you can understand it. So contracts have to be voluntary. That's the first thing. A contract has to be voluntary. You cannot force or coerce someone into a contract and have it be a binding contract. That's a word we haven't used, that binding. Binding just means the same thing as enforceable. It means a court of law would uphold it. If one party was forced to do it against their will, what do you think a court of law is going to say about that agreement? It's not valid. It's not an enforceable agreement because this party, this person was what? Forced. And we're going to talk about different kinds of force. We could be forced physically. That's called duress. If we're under duress. If I go and I present an offer to my seller on their property and they say, nah, I'm not going to take it, and it's $10,000 over full price in cash, am I going to be upset that they didn't take that offer? Sure. What if I pull a knife out and say, no, you can take this offer? Have they voluntarily agreed to that transaction? No. That's called under duress. They've made that choice under duress. And if they can prove that, then is that agreement going to be binding on them? No, because it's not a voluntary agreement. We need a meeting of the minds. We're going to talk about that a lot. We're going to this idea of offer and acceptance. Meeting of the minds means we have a clear path that shows the buyer has offered something and the seller has agreed to accept it. And that there's no difference whatsoever between what the buyer has offered and what the seller has accepted. Because you cannot change. You can't partially accept an offer. That's another thing that people get so confused about. Well, I accept your offer, except I want to change this. No, you don't. That's not accepting someone's offer. That's called making a counteroffer. You can't accept a part of an offer. An offer is a take it or leave it thing. And so this idea of having a meeting of the minds, we need to show clearly that the buyer and the seller both understand exactly what they're getting in for. Does that make sense for everybody? Everybody with me on that? Okay? You need to know this slide. The idea of legally competent parties. What makes a party legally competent? This is hugely, hugely important. The idea of legal competency is, in order to be able to be bound to an agreement, you've got to meet certain criteria. Not everybody has the ability to know what they are agreeing to. Not everybody has the ability to be bound by a contract. And so this list of things are things that would make someone not mentally competent or not able to enter into a contract. Look at the first one. It says they have to be at least how old? 18. In North Carolina, 18 is the age of legal consent for contract purposes. And actually, if you look at the statute, the law in North Carolina, it says if you're under the age of 18, you're defined as an infant. So if you have like a 17-year-old child at home, you might want to tell them what the law calls them. They'll appreciate that. They're defined as an infant in North Carolina until you reach the age of 18. Unless you're male, and then it's like 37 when that changes, you know. But you've got to be 18. And here's what this means. If they're not 18, can they promise to do something? Yes. Because there's a huge difference between what? Promising to do it and creating a promise that is what? Enforceable in a court of law. So now the second question, can they be forced to do what they promised they would do? No. If they're under the age of 18, they can promise to do it. But what value does that promise have? None. None whatsoever. Same thing is true for somebody who is intoxicated. If they're intoxicated at the time they make that agreement, they can promise, but the promise has no value because they can't be bound. It goes back to the whole idea of being voluntary. They can't be bound by a promise that they couldn't understand at the time they made it. Or if they're mentally incompetent. Now, I'm going to point out, you don't get to be the judge of that. I wish I could sometimes. I've encountered plenty of people who I thought, you got no business tying your shoes in the morning, much less selling a house. But I don't get to make that judgment call. When we talk about legal competency, we're talking about a court of law has said this person is not legally competent, so they've been appointed a guardian or something like that. Somebody has an unlimited power of attorney to make decisions for that person. You usually see this with people who are elderly, for example, and have reached an age where maybe they're not capable of thinking for themselves or making decisions for themselves. And so once they've reached that point and they've been declared mentally incompetent, they also cannot be held responsible for a contract because they're no longer able to understand that decision. Is everybody up good on these things right here? All right? This one is going to get you. Put a star, put an asterisk, circle it. You better tune in and you better listen. Because if you try to simplify what's on this slide, you will miss the test question about this. We say that a contract has to be supported by legal consideration in order to be enforceable. It has to be supported by legal consideration. Now, based on the picture here, what do you think consideration normally is? Money, cash. Here's what it actually is. Something of value. Anything of value can be consideration in a contract. Here's what this piece of the law says. It says, for a promise to be legally enforceable, then both parties must have promised to exchange something of what? Value. Notice I said both parties have to have made a promise to exchange something of value. Now, here's where you're going to get way off the rails with this and you're going to miss the test question because you try to overset. Nothing about contract law is simple. Nothing. You've got to dig 8 layers deep to get to where you're going with contract law. Nothing about this said that the consideration had to have already been exchanged. What I said is there has to be a promise to exchange something of value. So let me ask you, in a lease situation, what is it of value that the landlord brings to a lease? The property. What is it of value that the tenant has promised to bring to the transaction? Rent. So, if the tenant has agreed to rent the property for $1,000 a month, is that agreement or contract supported by legal consideration? Is it? Yes, because they've done what? They've both promised or agreed that they will exchange something. Here's what they're going to do to you on the test. They're going to say the rent hasn't been paid. They're going to say the rent hasn't been paid. And one of the answer choices is going to be, this is not a valid contract because it's not supported by legal consideration. And then your little nugget up there on top of your shoulders, you're going to say, oh, they didn't exchange money, so there must not be consideration. Baloney. Is there consideration? Yes, because they did what? They promised to exchange. Here's a newsflash for you folks. If they had already exchanged the money, there wouldn't be any need for a contract. Because they've already what? They've already finished what they promised to do. In a sales contract, what's the consideration from the seller's perspective? The property. Don't say house. Remember, there's more than just residential real estate, right? The property. What's the consideration from the buyer's perspective?
Money.
What kind of money? Don't say money, because there's going to be a lot of money, and this is why I got to get deeper. There's going to be a lot of money involved with a sales contract. There's going to be earnest money deposits. There's going to be due diligence fees. There's going to be additional earnest money. The sales price. The sales price is the consideration, the thing the buyer has promised to exchange. So now I'm going to expand that question out. Travis has entered into an offer to purchase and sale contract, selling his home in Cary to Lynn, the buyer. The contract specifies there will be no earnest money deposit or due diligence fee exchanged. Transfer of title is to take place on January 15th for the sum of $200,000. Is this a valid and enforceable contract? Yes. Why? Because we both promised what? To exchange something of value. Even though we specified there's no earnest money and there's no due diligence fee, does that matter? No, because ultimately have both sides promised to do something of value. Okay? Maggie has agreed to give her house to Chad, and they have reduced this to writing on a form prepared by Maggie's attorney. Is this a valid and enforceable legal agreement? Is it? No. Why not? Chad hasn't agreed to do what? To provide anything of value. Has Maggie agreed to provide something of value? Yes, the property. What did Chad agree to provide? Nothing. That is not a legally enforceable promise because it is not supported by what? Consideration. There's no consideration there. If Chad was smart, when he sat down and that attorney was drafting that agreement, what would he say to the attorney? Oh no, I insist I have to pay her something. Let me at least pay her $1. I have to buy her a double cheeseburger if she's going to give me her property. Would Chad be much better served by saying that he was paying $1 for that property than by Maggie giving it to him? Because if the contract simply says that Maggie is giving it to him and she changes her mind, what's Chad's recourse? Nothing. If the contract says that Chad is buying it for $1 and Maggie changes her mind, does he have some recourse? He can do what? He can sue her. You see the difference? That's what consideration is. It's the promise to exchange something of value. Now, this is another big requirement. Shocker here. To have a legally enforceable agreement, the promise itself, the thing they're promising to do, must be what? Legal. There's an earth-shattering thing, right? You're asking a court of law to enforce this promise. Do you think it's important that the thing you're asking the court to force somebody to do is actually legal? And I'll use an example, a real-world example, that happens every single day around us all the time. Do people make promises in a drug deal? Absolutely. Are they legally enforceable promises? They are? No. Because the underlying promise, the thing they have agreed or promised to do is what? Is illegal. So you cannot go to a court of law and go, Your Honor, we agreed he would sell me that 8-ball. And I would pay him this much money for it, and I paid him the money and he did not deliver the coke. You can't do that. That's not a good idea. I tell you what, you will find out a lot about legal enforceability that day, though, because it's going to be you'll find out not only that that contract's not legally enforceable, but there are several other things that are legally enforceable if you do that. Does that make sense for you guys? So one of the things you always have to ask yourself about a contract or a promise, and is it an enforceable promise, is the underlying thing that they promised to do, what? Legal. The thing they've promised to exchange with each other, is it a legal promise in the first place? Because you can't have an enforceable agreement where people have promised to do something that is against the law. They may have that promise with each other, but that's between them. The law is not going to step in and enforce that agreement because the underlying thing is against the law. Wouldn't that make not much sense at all if you could sue somebody and say, well, they promised to do this and the thing they promised to do was illegal anyway? You know, and no court of law is going to step in there. At least not that way. Okay, we good on that? All right. Now, you need to know the difference between express and implied. We've already talked about this previously. We talked about it in the agency agreements chapter. Remember, we talked about the difference between an express agency agreement and an implied agency agreement. What do we say an express agency agreement was?
Stated terms.
The terms have been clearly stated. I love that answer, Gerald. The terms have been clearly stated. Now, is a written agency agreement an express agency agreement? Yes. Is an oral agency agreement an express agency agreement? Yes. As long as the terms are clearly stated, it can be oral or it can be written. Implied doesn't mean just not written. Not only is it not written, it's never even been what? It's never even been discussed. It's never even been said. So take that to contract law. Could there be implied contracts? There are. And you deal with them a lot in your day-to-day life. That does not mean you want them in a real estate transaction. If you go out to eat dinner at a sit-down restaurant, and the server comes over and asks you what you would like to have, the terms of that agreement are never clearly expressed. That's not an express agreement. And here's how I know it's not an express agreement. When was the last time you ordered, okay, well, I'll have the ribeye, and they said, well, you know that if you have the ribeye, that's going to be $39.95 plus tax and gratuity. Are you okay with those terms? When was the last time they did that at a restaurant? If they do that at a restaurant, do you go to a different restaurant? They don't do that. We never really clearly express the terms. I mean, I've been in restaurants where there was no price at all on the menu. Well, you literally had no idea until the bill came. Are you still bound by that agreement?
Yeah.
Absolutely. So implied contracts do work sometimes. Not in real estate, though. In real estate, what kind of contract should we always stress? Express, and not only express, but what type of express should we always try to have? Written. We need to go to written. And what we're going to learn in this chapter is that sometimes we have to go to written. Sometimes we have to go to written with real estate contracts. Not every real estate contract absolutely has to be in writing. For example, leases. There are legally enforceable oral leases. That does not mean they're a good idea. And since you're going to be a licensed professional, what should you always insist your clients have with any agreement?
Right.
Have it in writing. There are going to be ones that they have to be in writing. So make sure you're good on the difference between express and implied. This is another set of terminology. This chapter is really all about terminology. Another set of terminology that tends to confuse people a little bit. The difference between bilateral contracts and unilateral contracts. Now, the terms or the prefixes bi and uni are pretty easy to understand. How many wheels does a unicycle have? Just one. How many wheels does a bicycle have? Two. So that part is easy to understand. If you don't know this picture, then I'm sorry, you didn't grow up in the greatest generation of people. This was probably before we went to the movie theater. That's also a reference for some of you who did not grow up in that generation. He looked excited. He didn't be going wherever he's going. But a unilateral contract is one where only one of the two parties, because there's still going to be two parties. Here's the thing. There's no such thing as a legally enforceable contract with yourself. Every party has, or every contract has two what? Parties, two people who have agreed or promised to do something. The question is, how many of them have actually made promises? And in the case of a unilateral contract, only one of the two parties has made a promise. One of them. What does that mean the other one can do? If you haven't promised, what can you do? Walk away. Back out. There are contracts where only one side has made a promise. Where one of the two parties has promised to do something, but the other side is just not locked in. They've not made that agreement. They've not made that promise. Are you following me on that? So let me give you an example of that. Well, the easiest example is probably just an offer. If you take an offer, for example, and Jay makes an offer to purchase a house from Gerald. Jay offers to purchase Gerald's house for $250,000. Puts it on a standardized form on a contract. He signs the offer. He sends the offer over to Gerald. At that point in time, how many parties are there to this agreement? There's two parties. There's Jay and Gerald. There's a buyer and a seller. Don't answer what you think I'm going to ask you. Answer what I ask you. How many parties are there? Two. How many of them have promised to do something? One. Only Jay, the buyer, has made a promise at all. What has Gerald promised to do? Absolutely nothing. So is Gerald bound to act in any way? No. Is Jay bound to act in any way? Yes, he is, because he's made a what? A promise. If Gerald were to accept that offer, what kind of agreement would we then have? A bilateral, because at that point in time, would Gerald have made a promise in exchange for Jay's promise? So most real estate contracts are going to be what type of contract? Bilateral or unilateral? They're going to be bilateral. Well, let's give you an example of another unilateral contract, because I feel like this is one of those things that we can't talk too much about, because you say you got it, but you don't really got it. So let's say that Jocelyn is looking to purchase property for her buyer client. Her buyer client is Walmart Stores Incorporated. That's who she represents. Would that be a pretty good client to have? Not bad. For your first client. I doubt that's going to be the first one, but... So Jocelyn has Walmart as a client, a buyer client, exclusive buyer agency agreement. So she represents Walmart's best interest. Does that make sense for everybody? Now, Walmart has decided that they are going to relocate to a certain town. And they're going to relocate to an area where there are 3 potential properties that would work. 3 potential pieces of land that would suit their needs. Does everybody follow me on that? Now, Walmart needs to do a bunch of research to decide which one of these 3 is going to be the one. I mean, they need to go talk. Are they going to have to talk to the city about zoning? Are they going to have to talk to the Department of Transportation about widening the road wherever they're talking about putting this store? Because these are just 3 fields, by the way, right now. So they're going to have to talk to people about putting in additional turn lanes or putting in stoplights. And who's going to have to bear all that cost, by the way? Walmart is. But they need to figure out which one is going to cost more, which one's going to be the easiest, which one's going to go the simplest with the city. Is everybody following me on all that? So here's Jocelyn's choices. She can go to the town and she can start to inquire about the zoning of each of these 3 properties. And then she can contact the Department of Transportation and say, we'd like you to come out and do what we call a feasibility study. That just means a study to look and see if this is going to work here. So she's got the Department of Transportation to come out and do a feasibility study on each one of these 3 properties. Now, John owns one of these pieces of property. Jan owns one and Dave owns one. Are the 3 of them going to notice people from the city out at their property now looking around? People from the Department of Transportation out there? Is the Department of Transportation likely to reach out to the property owners? Absolutely. So now Jen finds out from her friend that works at the Planning and Zoning Office, girl, you know, that's Walmart looking at your land out there. What happens to Jen's asking price on that property? It goes up. Now, it doesn't really matter at this point because we haven't negotiated a deal yet, right? So now, what was the whole purpose of Jocelyn doing all this research? To decide what? Which one of the 3 they wanted to locate on. So now she's done her feasibility studies, and here's what she's found out. With Dave's property, the Department of Transportation is requiring her to put in a 4-way intersection complete with 2 green arrow turn lanes, dedicated turn lanes with green arrows. They have to widen both sides of the intersection. So they need additional lanes at both directions in the intersection with turn lanes with traffic signals. Estimated cost, $345,000 in development expense to put that intersection, because that's what the DOT says it needs in order to manage the traffic that's going to be created, because this is going to create additional traffic to put a Walmart right here in the middle of this highway. $345,000. She gets a feasibility study back on Jen's property, and because of the location and where it is and its distance from other intersections, etc., the Department of Transportation has said that all you need here is a middle turn lane. You need to go, it's 1 lane each direction right now. You just need to widen this section of the road for a half mile, quarter mile on either side of the store. It needs to be widened out to 3 lanes with a middle left turn lane down the center. Estimated cost, $50,000. And the Department of Transportation has said that on John's property, it is not feasible. It cannot be done. We will not allow this development. So now, let me ask you a question. Has the decision been made about which property it's going to be at this point in time, most likely? Yeah, well, we know John's is what? Out of contention. So that leaves us with Jen and Dave's, and what do we know about Jen and Dave's? There's a $300,000 difference in development costs between the two of them. Which one is Walmart likely to choose? If considering everything else is equal, which one are they likely to choose? The cheaper one, Jen's. Now, is Jen going to be very aware of that? Absolutely, because these feasibility studies, folks, they're public knowledge. The Department of Transportation will tell these property owners what that feasibility study shows. So is Jen going to use that as a negotiating tool in her negotiation with Walmart? Did her price just go up? Yeah, how much? Maybe not 300, but at least 200 or 250, right? Because her response is going to be, what are you going to do, buy the other one and spend more than that? See where I'm going with this? Jocelyn did not do a very good job for her client. Because what Jocelyn should have done in the beginning, before she started talking to the Department of Transportation, before she started talking to the town of Zebulon, before she started having those conversations with anybody, she should have visited John. She should have visited Jen. And she should have visited Dave. And she should have negotiated a purchase price on all three of those. And then she should have said, we're not 100% sure if we want to buy your property yet. And by the way, is she going to be negotiating as Walmart stores? No, she's going to be hiding that identity like crazy at that point in time. Because she doesn't want, because would that hamper the negotiation? Yeah, she's just, you know, Blue Ribbon Properties LLC, whoever the hell they are, right? And so she goes and she sits down. And by the way, does John know this negotiation is also going on with Jen? No. Does either one of them know that Dave's also involved? All they know is a buyer has popped up, all of a sudden shown interest in property that they've had for a long time. And here's what the buyer's saying to them. We'll pay you $500,000 for your property. But I need 6 months to decide if it's really what I want to do. So I'll cut you a check right now for $20,000 today. An option fee. I'll pay you an option fee. And so what you agree is that if during the next 6 months I decide I want to do what? Purchase your property, you will sell it to me for $500,000. Is everybody okay with that?
Yep.
How many of those three is she going to do that with? All three. She's going to pay every single one of them $20,000. Boom. 60 grand out the door. How many of those properties is Walmart going to ultimately buy? One. Here's the advantage of that. Can she have a damn press conference the next day and say, Walmart's coming to town?
Yep.
She sure can. Can she do her feasibility studies without worrying about who finds out who she's really shopping for? Can Jen renegotiate her price when she realizes she's the only property that actually works for Walmart? No, because Jen has actually made a promise. And what is that promise that Jen has made? To sell the property at that price within the next, what? 6 months. Has Walmart made a promise to Jen? No. Has Walmart made a promise to John or Dave? No. They paid an option fee that prevented them from having to make that promise. That's a unilateral contract. It's also known as an option contract. Does that make sense for everybody? Yes, sir.
That option fee is non-refundable.
The word fee indicates non-refundable, yes. Yep. Option fees are non-refundable. I'm sorry?
So I get 520,000.
Well, that's going to, Jen's question is, does she get 520 or does that 20 count toward the purchase price? In most options, the option fee counts toward the actual price. So it would probably be, they would owe you a difference of 480, which they have in their couch cushions. So, you know. Okay, we good on the difference between bilateral and unilateral? It's not the number of parties, it's the number of parties that have done what? Have made a promise to each other. Yes, sir.
Now, on the slide before, have you taken note that contract requirements require both parties to offer something of value?
Talking about this one?
The
Consideration slide?
Yes.
Uh-huh.
Yeah. And then now, we're discussing contracts,
Mhm.
not require both parties, so.
There is the promise to exchange something of value.
I'm gonna give the property.
The seller's bringing the property, and the buyer is bringing the purchase price, but only if they decide they want to make that contract enforceable. So by the buyer saying, I'm exercising my option, they've now made it a what kind of contract? A bilateral contract. So eventually it would become bilateral with one of the three,
Okay,
and be terminated with the other two.
something of value has to be present on both sides.
Promised in the future.
But the, demand to go through with it is not necessarily there.
That's exactly right. That's exactly right. Okay? Another piece of terminology or pair of terms that get often confused. The difference between executed and executory. And I have taught this a number of ways over the years, and none of them has worked as well as the most morbid way I can possibly think of to teach this. Folks, if you are walking to the electric chair, you are executory. When they throw the switch, you executed. Contracts work exactly the same way. When they are signed and promised, they are executory. When they are closed, they are executed. An executed contract is one where all the promises have been completely fulfilled, where those two parties have done everything they promised for each other. That's an executed contract. So, in the case of a sales contract, if you saw this on a test, if you saw on a test that, let's say, two parties have signed an offer to purchase and contract on the standard form from the North Carolina Association of Realtors with an anticipated closing date of August 28th for an agreed upon purchase price of $350,000. This is an example of, is that an example of an executory contract or an executed contract? That's an executory contract because it has simply been what? Signed and promised but not delivered on yet. They haven't closed. They haven't accomplished the goal. That's when it becomes executed. Does everybody see the difference there?
Yes.
Okay, good. Good. Because people tend to get that, and that gets misused a lot in the real world. You'll hear a lot of people, even in the business, who miss, can you send me a copy of the executed contract? My skin crawls every time I hear it. Hey, you want to say, no, I can't, because if it was executed, we'd already be closed and you wouldn't be asking me for a copy, but you do that and they don't like you very much. So I send them what they want. What they really want, though, is what? The executory contract. Good. Good. And then that brings us full circle back to the magic word, enforceability. Is this agreement enforceable? Do we have an enforceable agreement? And so we want to make sure that as much as possible we do have an enforceable agreement, which just simply means that the two parties, both of them, would be held responsible in a court of law. That's what enforceability is about. It's about, would these two parties be held responsible? We can't really force them to do what they promised to do in every case. Some cases we can. We'll talk about specific types of lawsuits, for example, where you're not suing asking for, oh, they've harmed me, make it better. You're suing and saying, make them do what they promised to do. That's one type of lawsuit. It's called specific performance. But then there's, most of the time when you're suing somebody because they haven't done what they promised, what are you suing them for? Some kind of what? Compensation, damages. You want damages. They damaged you because they did not do what they promised to do. What is the fancy contractual term for not doing what you promised to do? A breach. A breach of contract is when you, well, folks, you can't have a breach of contract unless the contract was first what? Enforceable. If it was never enforceable in the first place, it's impossible to breach it. You can only breach contracts that are enforceable. And enforceable only matters in a court of law, because that's where this would get decided. That's where we would make the decision of, is this an enforceable agreement? Is everybody good with that so far? Okay. Now, The next 4 terms, there's 4 vocabulary terms that are coming up. Valid, void, voidable, unenforceable. You will see test questions about them. Probably more than 1, maybe 2 or 3. And I can guarantee you that they will be the most commonly missed test questions on the exam, because they always are. Because people forget everything that we've said thus far about contracts. What did I say a contract was? It's a document that shows the world that you've done what? Made a promise. The contract's not the promise itself. Enforceability really has nothing to do with making a promise. Enforceability has to do with keeping it, following through, somebody forcing you to follow through. Well, and what do you think is going to be step 1 in getting somebody to follow through in a court of law? What do you think you're going to have to present, first of all, to show that they made a promise in the first place? A contract of some type. It's very hard to go to a court of law and say, Your Honor, they didn't do what they promised to do, if you don't have any proof of what they promised to do. Does everybody follow me on that? So let's talk about this word, valid. This is good. Valid is good. The rest of these are bad. Okay? Valid is the only good status for a contract to have. Because what valid means is that the contract itself is enforceable on both the parties. A valid contract is one that's enforceable on both parties. Here's what you need to understand about contracts. Don't think of them like a glass that once it gets broken, it's just broken and neither party has anything left. Think of a contract like a rope. And it's tied around 2 people's wrists, 1 at each what? End. How many people are tied up in a valid contract? 2. And what we mean is that that knot is securely fastened around the wrist of both parties. So in the case of a sales transaction, the buyer is bound and what? The seller is bound. That's not going to always be the case. There are going to be times when not both of them are bound, when only one of them has actually promised to do something, or, more importantly from a legal standpoint, is going to be bound to do something. Because maybe they couldn't promise it, maybe they shouldn't have promised it, maybe they did promise it, but something happened along the way, like a breach. That's going to change the a valid contract means both parties have promised to do something. Both of them are bound to do what they promised to do, and neither one of them has messed up to this point. They're both following what they promised to do. So valid means everything's in order. Does that make sense for everybody? Everything has gone right. So think about all those rules that we talked about. What do we know about the 2 parties? They're at least how old? 18. Are they drunk or sober? Sober. Are they mentally competent? Yes. Is there consideration in place? Yes. Is there a meeting of the minds? Have they agreed? Yes. See, to be valid, everything has to be in place. Does that make sense for you guys? The rest of these statuses that we're about to talk about, something's wrong. Something either was wrong from the beginning or something has gone wrong along the way. With a valid agreement, everything's right. Does it make sense? This is where you'd want to be as a real estate broker. You'd want to have your agreements be valid agreements. Everybody okay?
Yep.
All right? So, voidable. Probably the single one most likely to get you wrong on a test is voidable. Voidable, for whatever reason, is a status that people have problems with on the test. I can't explain why the problems exist. I wish I knew better. But voidable, we're sort of on a countdown here. We went from valid, where how many parties were bound? 2. We just counted down. How many parties think are bound now? 1. How many parties does the contract have? 2. But only one of them what? Is bound. Now, notice I didn't say this is a unilateral contract. Both of them promised to do something, but now only one of those promises is what? Enforceable. Only one of the parties can be held responsible for what they promised. One of them cannot. There are a variety of reasons why one of them might not be held responsible. This picture is a good example of a case where one party is not going to be held responsible. Generally speaking, if one party has to sign in crayon, there might be a problem with that contract. One of the classic examples of a voidable contract would be, for example, a contract with a minor. Now here's what you need to understand. The words void and voidable just sound alike, but they have nothing to do with each other. A voidable agreement is a completely legal agreement. There's nothing wrong with what they have promised to do. So if this is a sales contract and the little boy on the left is the buyer and the gentleman on your right is the seller, what is it that they've promised to do?
Play for the Jazz.
And play for the Jazz? Yeah, I know. Wait, I mean, but if this is a sales contract, what did they promise to do? Exchange something of value, a property, right? The buyer on the left has agreed to do what? Buy. And the seller on the right has agreed to do what? Is that a legal promise? Yes, there's nothing wrong with what they're promising to do. Are you following me on that? There's nothing wrong with the promise. The problem is with the parties. Specifically with how many of the parties? One. One of the parties is fine to make this promise legally. Which one is okay to make this promise legally? The old man, the adult, right? Which one is not okay to legally make this promise? The minor, the child. So here's what how we would refer to that contract status. That is a voidable contract. And what that simply means is that one side of it is going to be held responsible for the promise, while the other side is what? Is not. Which one do you think is going to be held responsible here, the adult or the child? The adult. So the contract would be voidable at the option of the child. The contract is voidable at the option of the child. What that means is that the child can do what?
Walk away.
Walk away. Not be held responsible. Can the adult be held responsible? You better believe it. Here's the truth of this matter. If this is a sales contract and that child wants to go through with it, and this gentleman says, you know what, the whole thing was a joke. I was just kidding around. I'm not selling you my property. I'm not selling you the Jazz. Is that a legally enforceable agreement from the child's perspective? In other words, can the child sue the adult and force them to go through with that contract? Yes. And that's how you know it's a voidable contract, because one party still has legal recourse, but the other one what? Does not. If the child backs out, walks away, laughing the whole way, what can the adult do about it? Nothing at all. One side still has legal recourse, and the other side does not. Does that make sense for everybody? So something's wrong with one of the parties. Another something that could be wrong with one of the parties. Notice it says right here, could result from a breach by one party. Here's where it starts to get confusing for people. Could we start here at valid and end up here at voidable?
Yeah.
Yes.
If one does say one party don't have the money.
There's a breach. What if we start as valid? Both parties completely okay. They're both adults, they're both sane, they're both sober, there's legal consideration. Do we have a valid agreement?
Yeah.
Yes. One of them breaks a promise. The seller promised as part of the transaction they would replace the deck. We get to the day of closing, the deck has not been replaced. Has the seller breached the agreement? Yes. Is the seller still bound to the contract? Yes. And the other way of asking that is, if the buyer still wants to go through with it, does the seller have to go through with it? And so the seller can't say, oh no, I didn't replace the deck, so I'm also not going to sell you the property because the contract's been breached. It doesn't work that way, right? The one doing the breach doesn't get to decide to walk away. Who gets to decide to walk away? The other side, the party who was harmed. Don't just say the buyer, because could those roles flip, right? It's the other side who gets to decide to walk away. So in that case, it's the buyer who could walk away because the seller has broken a promise. Does that make sense for everybody? That would be a voidable agreement, because at that point in time, it's only enforceable on one party, not on both.
Now what happens if the kid is a minor, but you know how it says like your parents sign after? There's still a minor, like if not 18, parents have guardians.
You have a legal guardian sign? That would, so Tommy's question is, what would happen if a guardian, a legal guardian signs in place of the child or in addition to the child? Then it would be a valid agreement, because that legal guardian has the right to make that decision on behalf of the child. So this would be so there's value in this. You may at some point in your real estate career run into a transaction like that. Most likely not with a buyer. You could run into a transaction like that with a seller. What if there is a teenager whose parents are both killed in a car accident? And they're 16 years old. And their grandparents are now their guardians. Do their parents likely have a will?
Yeah.
And who did it likely leave ownership of all of their property to, including their real estate? The child, right? The child is going to sell his parents' home. Can he legally be held to that agreement himself? No, but could his guardian sign that agreement and make it a valid and enforceable agreement? So if you were representing the buyer in that transaction, you wouldn't be satisfied with seeing the child's signature on that sales contract. You'd also want to see whose? The guardian's, because that would be what would make it. Because if you just had the child's, you'd still have a promise, but it wouldn't be a legally enforceable promise. What kind of contract would you have? You would have a voidable contract, whereas if you got the guardian's signature as well, it would be a valid contract. Good. Does that count if it's a minor but they were emancipated? I'd have to go back and look at the statute on that. My thought process is, if they've been emancipated, they've been granted contractual ability by the court. An emancipated minor, generally speaking, functions as an adult. The courts essentially said, you know, we feel that they are perfectly capable of making their own decisions, and so they've been given that contractual authority. It's very unlikely that you would deal with that in a transaction. That's a very rare thing to deal with. If you ran across it, I would certainly get an attorney involved and say, okay, what exactly do we need? Who needs to sign this thing? And as a matter of fact, even if you ever ran across the one with a guardian, I'd get the attorney involved and say, anytime you have an out of the ordinary transaction, like the closing I have on Wednesday, for example, is an estate sale.